Linda Anderson. I'm the principal of Anderson Elder Law, and I have been so lucky. In 1987, when I was working at a larger firm, my then boss said, by the way, I want you to keep track of those nursing home rules. And that was at a time when there were no treatises. It wasn't a body of knowledge that was even referred to as elder law at the time. But at that moment, he put me on the path to be doing exactly what I was meant to do. And so since 1987, I've worked almost exclusively in the areas of elder law and special needs planning. When I think about how lucky I've been, it's because of the incredible clients that we've actually served and the idea of being able to take people that are many times in crisis and actually start the planning, implement the planning, and making sure that everything turns out as best as it can be. So for instance, some of our clients are not in crisis, are just typically looking for estate planning documents. And what I would want you to know is that there is a way to do estate planning documents, being a will, power of attorney, healthcare, power of living will, to do those documents in a way where there are elder law enhancements that will actually make a difference if something happens that's unrelated to who gets your assets when you pass away. And for our estate planning clients, what they find is that their long-term care insurance is reflected in the documents that we have, not only for them, but for their surviving beneficiaries. In terms of our elder law clients, what we find is that our team really has to be comprised of others with different kinds of expertise. So we have certified elder care coordinators that work hand in hand with our certified elder law attorneys and our other professionals who absolutely come from an aging background, but also all of us have life experiences. And so our elder law clients may be somebody who has just gotten a scary diagnosis, perhaps like early Alzheimer's, or perhaps there's been a family member who's had an acute crisis, such as a stroke. And the idea is that any day that you need to talk to somebody about not only estate planning and surrogate decision making, but paying for long-term care and utilizing public benefits, and then with a coating of icing of care coordination, that's not a good day for those families. And that is exactly what elder law does, and our firm follows the life care planning model. And so it's much, much more than knowing just about those nursing home rules as I was directed in 1987, and the idea of knowing how to do holistic planning with all of the multiple disciplinary team members we have is absolutely what many families need. The other use for all of the sophisticated knowledge that we have about public benefits and surrogate decision making and sophisticated estate planning is also reflected in our special needs work. And the idea is that there may be people who are disabled or have a sudden injury and pushed into a situation where they themselves may need to access public benefits, but their family members may need to be able to adapt their estate plan to protect those safety nets and benefits. And when you think about special needs planning, this is one of the most personal types of planning, especially when it's for a parent that has a child, whether it's 3 months old or 60-year-old, but having a special needs child is a special responsibility, and those files and that work is some of the most important and satisfying work that we do. So our clients with special needs have the same goal, self-determination, and making sure that they have as full a quality of life as they possibly can. And the family members that help and support those goals are often struggling to make sure that they're doing everything possibly that they can. When you think about special needs planning, it's typically divided into two types. One is called third-party planning, so that parents or other family members are making sure that their estate plan is designed to absolutely support that person in a way where we are not jeopardizing public benefits, but still giving as much flexibility as we can to the resources that are passed to them. The other type of planning for a special needs person is called first-party planning. And so the special needs person, they themselves are getting resources that may impact their public benefits. And so the work for those clients is to look at all the tools, whether it be a first-party trust, a pooled trust, or an ABLE account. All of these things can be blended to make sure that, again, self-determination and a wonderful quality of life, that those are the goals that everyone has, that those goals are met. So when I think about our firm and I think about 1987, I realize I have been so lucky to be able to do the work for all of our clients, and even luckier to be able to work with the people that are on our team. I invite you to contact Anderson Elder Law and to get started doing what matters with us.